This is Lecture 9, Novelty 3, Statutory Bars. The agenda for this lecture is to discuss the various, obviously, statutory bars associated with the patent law. Note, of course, that these pertain primarily to the pre-American Invents Act, so pre-March 2013 patents. Obviously, they still have relevance because those patents are going to be in force for a couple decades yet. So that's why we study them. And also we study them because some of the language of 102B, the statutory bar provision, remains in 102, and therefore the case law is applicable even to more modern post-AIA analyses. So we're going to talk about the on-sale bar, prior public use bar, the experimental use exception to the statutory bars. There is an exception for experimental use. And then discuss how third-party activity can create a statutory bar. Typically, we think of statutory bars as being things that prevent the patentee, him or herself, from getting a patent on their invention. But in fact, the courts have interpreted the bars in such a way that allow third-party activity to be bars as well, and we'll talk about that. So the one thing I want to do before we get too far in is talk about what we mean by statutory bars in the context of novelty, right? You'll remember it is listed on the standards of patentability. A valid patent must be described, novel, in compliance with statutory bars, right? So one of the issues is patents must be novel in this, by which we mean new, meaning the same thing can't already exist in the prior art, and they must comply with statutory bars. Now, shouldn't novelty be enough? Well, at least until the American Invents Act, when we changed to a first-to-file system and did away with this concept of invention date as a relevant concept for patentability. It is important to have a statutory bar, in part because 102A states that prior art is only good as against a patent if it is before the invention date of the relevant patent, right? And so obviously if there's a variety of opportunities for prior art to arise that are not before the invention date, and when we would still want there to be a bar or a prevention of the patent, right? And that's where the statutory bars come in. Right, the statutory bar, this concept of having a statutory bar, arose in the classic case of the Pennock versus Dialogue case. There's a new process developed for watertight hoses, which the inventors initially wished to keep as a trade secret, and then they later decide to claim as a patent. Right? So what they were doing was, for many, many years, they would produce hoses using this new process, keeping it secret, and then later, only later, did they go and attempt to get a patent. Right? The court in Pennock says this is impermissible. Right? And the court said that even though at the time the statute didn't expressly say there was a statutory bar, the Supreme Court says it is impermissible to allow the patentee to commercially exploit his or her invention and then later attempt to patent it. Right? The court says in doing so, you're essentially getting the best of both worlds. You are, in a sense, cheating the public because you are both taking advantage of the patent system and enabling yourself to reap additional commercial rewards by keeping the patent out of circuit, or keep the patent from being applied for until later. Right? You can also think of this another way, which is it's a way of getting a de facto longer patent term by allowing there to be a pre-period where you commercialize your invention, keeping it secret, and then later go in and get a patent. right? So the Pennock case in 1829 stands for the proposition that even the true first inventor is not entitled to a patent if the invention is offered to the public too early, right? And too early meaning too early before the patentee seeks the protection of the patent regime. The current statute has a grace period of 1 year, right? So the idea here is that there's a 1 year grace period. Within that 1 year, you can publish or sell your invention without detrimentally affecting your patent rights. Before the 1 year, you're going to detrimentally affect your rights. Now let's talk about the bars themselves, right? So the on-sale bar is found in 102B, right? Person shall be entitled to a patent unless the invention was on sale in this country more than 1 year prior to the date of the application for the patent, right? So that's the basic standard. If it's on sale more than 1 year prior to the date of invention, then the bar is met, right? The issue here, and it's what's shown in PFAF, right, is what do we mean by the invention is on sale, right? And the PFAF case raises this question, right? Because what PFAF sold were diagrams and descriptions and a design for a patented product, but not necessarily the thing itself. And the question raised by cases like PFAF is, at what stage of completion does your invention have to be in order to trigger an on-sale bar, right? So it's obvious that if I am claiming a pencil, for example, and I, outside of the 1 year grace period, sell somebody my patented pencil, so that it's obvious that triggers the bar, right? But what if I haven't finished quite made my prototype, or I haven't actually produced anything related to my pencil, and instead all I have is sort of the idea and the design for the pencil? What then, right? So how do we know whether that is a sale of the invention or an offer to sell the invention, or is that nothing, right? And so the PFAF case by the Supreme Court tries to answer that, and they essentially establish a timeline that's up here, right? So few concepts to get your head around here. First, obviously, is application date, all the way there to the right, the date of application, the date you file, right? And then there's the 1 year grace period, and then at the 1 year date prior to the application date is what we call the critical date, right? That's the date before which these potentially barring activities will have to occur, okay? So what PFAF holds, right, is that once you've reduced your invention to practice, you have clearly gone far enough to create a bar triggering event, right? So certainly once you have reduced to practice. All right, what does reduced to practice mean? Typically, we think of reduction to practice as the creation of a prototype, right? That's sort of the classic reduction to practice. You've created a prototype that has all of the elements of the claim worked out, okay? You don't always need to some things can't be reduced to practice by the creation of a prototype, for example, a method, right? But essentially, if you have perfected your invention, you have worked out the kinks, your invention is essentially done. That's what we mean by reduction to practice, right? You have reduced it to its operational form. It's done, okay? You may tweak it just a little bit, but not in sort of a material way to the claims. So once you're at that point, you clearly can trigger the bar if you sell, right? But what the Supreme Court said in PFAF is that you can trigger an on-sale bar even before that, right? And perhaps even as early as conception, right? So now this introduces another concept, right? Conception of an invention, right? So when you conceive of an invention, right, the definition of that is that you've, in your head, worked out all of the elements of the claims, right? You may not have actually made this invention work yet. You may not have made any prototypes, for example, or done anything like that. But what you've done is essentially worked out everything in your head that needs to be done for invention. All of the elements are sort of there in your head at that time, even if you haven't sort of finished the invention. right? So that's conception, right? Now there's this period between conception and reduction to practice that PFAF says could create a bar or might not create a bar. And what PFAF establishes is yet a third stage of development, which it calls ready for patenting, right? And the court in PFAF says if it's ready for patenting, then any sales of the invention after it's ready for patenting will be a bar triggering event. All right? And so what is ready for patenting? All right? Well, what the court describes is, you need to, at the time that it's ready for patenting, you need to have drawings or descriptions sufficient to enable a person of ordinary skill in the art to practice the invention. Doesn't mean you actually have to have everything reduced to practice, but it means that you've got some diagrams worked out that are enabling. It means that you're, the detail at which you're sort of operating these designs is sufficient to enable somebody. That's what they mean by ready for patenting. All right, and so a question to ask yourself is, how different is this really from conception, right? If conception is you've got all of the ideas already in your head, and ready for patenting says you're essentially creating an enabling description. Note that those are pretty close concepts, except for perhaps for the idea that ready for patenting implies that you've taken some activity, you've drawn some plans up, you've created some description, you have communicated in some way to other people how the invention works in a way that would allow them to use it. So that's what I think the court means by ready for patenting. Now, where is it between conception and reduction to practice? We don't really know, right? And a lot of that may depend on the type of invention involved, right? Some types of inventions, as soon as you conceive of it, right, say it's a new taxing strategy or something like that, maybe as soon as you've worked it out in your mind that how this thing works, you have effectively reduced that to practice, right? Meaning there's no more to do, right? It's a method, it's a particular financial scheme or something, and you've already worked it out. So that may be where you have conception and reduction to practice that's either simultaneous or nearly simultaneous, right? On the other hand, there can be other types of inventions, right? Maybe very high-end genetic inventions or something like that would take, you might have a glimmer of an idea of, a pathway that you want to follow, and that's sort of your conception, but it could take years, perhaps, of research to sort of create the proofs required to fully enable and understand that this invention is going to work, right? So you might have a very long period between conception and reduction to practice. So just note, I just want to flag for you that gap there that's in the blue on the chart will vary considerably depending on the particular technology involved, all right? So ready for patenting may be satisfied in two ways: proof of reduction to practice, or by proof that prior to the critical date the inventor had prepared drawings or other descriptions that were sufficiently specific to enable, right? So this is sort of once you are sufficiently far along to enable others, then your invention is ready for patenting, and then anything you do to sell or offer to sell your invention at that time could be a bar triggering event, right? So this is the standard for conception, Brown versus Barbasid. Put it up there. Conception must encompass all limitations and is complete only when the idea is clearly defined in the inventor's mind, right? Without extensive research or experimentation, right? So again, this is what PFAF really does is, in a sense, it links the on-sale bar in a sense to the priority rules, right? One of the things that's interesting about PFAF is it says because the amount of proof that you would have to show, in order to show, for example, that you have priority over a competing inventor. Remember, we talked about this in the last class, about the need for corroborating documentation about your invention dates, your reduction of practice dates, things like that. PFAF links that by saying, once you've prepared those things that would help you in a priority contest context, then that could be exactly the type of materials that would be sufficiently descriptive to call the invention ready for patenting and therefore create an on-sale bar. Okay, so that's the on-sale bar issue, and really, again, it's a relatively simple and straightforward thing, right? As far as what sales are, the Federal Circuit has said many times that they use, in general, they use issues related to, they look generally at basic contract law, although the court is rather nebulous about exactly what kind of contract law it uses, and it doesn't really use any particular contract law for that. It sort of is a know it when you see it activity with respect to what kind of offers are really offers to sell. So that can be a little confusing, but usually where most of the action is on the on-sale bar is in the cases like PFAF, where what is sold is not so clearly the invention, but instead some precursor to the invention, like a plan for an invention or an agreement to supply the invention that might have some description or might not. That's usually where the difficult points are with respect to the on-sale bar. All right, so prior public use, right? So prior public use is also a 102B. The invention was in public use more than 1 year prior to the date of the application. Again, similar critical date issue, 1 year grace period, public use, right? The one important case for this is the Egbert versus Lippmann case. This is the corset springs case. This is a fun case. The invention was completed and put into use. This is a new and improved method for corset springs. It was completed and put into use in 1855. It was tested for many, many years, apparently. The patent was applied for in 1866. So over that course of 11 years, the inventor's intimate friend, according to the opinion, was involved in testing this, and this testing occurred in public. Very often she would wear the corsets with these corset springs, these new and improved corset springs. And the question is, like all of these, is this, what's the critical date? And then was there a public use prior to the critical date, right? And the interesting thing about Egbert versus Lippmann is that clearly they were using the corset springs prior to the critical date, right? There's really not a question about that. But their use was hidden, right? I mean, the very nature of corset springs are that you're not supposed to see them, and there's really not a lot of evidence that the public generally knew about them or even knew that the inventor's intimate friend, girlfriend, wife, not sure, was actually wearing them at the time. And so what Egbert had to deal with was how do we analyze that? Is that a barring prior public use, right? And this is so the critical date here would be July 17th, 1865. If we had the current law, as a technical matter at that time, there was a 2-year grace period, but in any event, it's clear that there was a lot of use going on well prior to the critical date, right? And so what the dissent, so the majority finds, right, that this is a prior public use, that this use of the corset springs, even though they could not be seen or revealed by the public, was nonetheless a prior public use according to the statute, right? And a private use and there was a vigorous dissent in this case, a private use with consent, which could lead to no copy, no reproduction, which taught the nature of the invention to no one but the party to whom such consent was given, which left the public at large as ignorant as before the author's discovery, was no abandonment to the public, and did not defeat the claim for a patent. if the little spring inserted in the single pair corsets used only by one woman, covered by outer clothing, in a position always withheld from public observation as a public use of a piece of steel, I am at a loss to know the line between a private and a public use. Right? So I think that Justice Miller has a good point there, but what the majority was mainly interested in is that they're, again, going back to that Pennock versus dialogue concept, which is part of what we're trying to do with the statutory bars, is not merely police novelty, right? Not merely make sure that you can't get a patent for things that have already been given to the public, so to speak. But what we are also trying to do is to make it so that the patentee can't get a de facto expansion or extension of his or her patent rights by keeping an invention secret and then later applying for a patent when convenient. Right? And it's that second one that really was animating, I think, the Egbert versus Lippmann case, right, where the court really seemed to think that this long delay between the development of the springs and the uses of them over this long period was simply too long, and it allowed the patentee too long to rest on the rights before seeking patent protection. Right? Now note that this is still not an entirely satisfactory explanation for the result, because even though the patentee clearly used the springs for a long time, there's no evidence that the patentee was commercially exploiting this in any way. It's not like the patentee was selling the corset springs, right? The only evidence we have is just this one woman was wearing the springs around. So it's a little bit of a difficult case to understand, but it does stand for the proposition that it's not solely about novelty. Statutory bars are very formalistic. They're not solely about novelty, not about when things are given to the public necessarily. They're also very much about the behavior of the applicant, inventor, him or herself. Right? The other thing to understand is that what the court is trying to do is make sure that different technologies don't get treated too differently in this context. Right? I mean, if there was a rule saying that, if you are using your invention in public but no one can tell, then certain kinds of inventions would have a significant advantage with respect to these public use and on-sale bars, right? Because they would be able to be used, exploited even, potentially, without the public knowing. Right? And so I think one of the things that was animating the court is you want to make rules that apply as equally as possible to different kinds of technologies, and that having a rule that would affect different technologies differently, and in this sense give advantages to certain kinds of technologies that are difficult to observe, could be bad. Right? So the Motionless Keyboard case is another prior public use case. Right? So there's a sole inventor of two patents here. He invented an ergonomic keyboard and a mouse, he invented these as a part-time basis while working in other jobs, such as a graphic artist and dishwasher. Right? As an independent inventor, he developed his technology without the benefit of well-funded laboratory, and then had very limited resources to apply for patents. Right? So our first step here is to try and figure out what the critical dates are. Right? This is the way I recommend you go about any analysis of a statutory bar issue, is first try and figure out what the critical date is. All right? So the 477 patent was filed on June 6, 1991. That means the critical date for our purposes is June 6, 1990. So anything that happens after June 6, 1990 is irrelevant from a statutory bar purpose for our purposes. Right? The 322 patent, the other patent, has a critical date of January 11th, 1992. Okay? So, again, things that happen after that date we're not going to care about. Right? Second step of the analysis, what activities were occurring prior to these critical dates that might trigger a public use bar? Right? So it's clear that the inventor had created what's described in the case as Cherry Model 5, an embodiment of the invention of both the 477 and 322 patents, right? And the inventor disclosed Cherry Model 5 to his business partner, to some potential investors, to a friend, and a typing tester before the critical date, right? The potential investors sign NDAs. Some of these NDAs expired in 1989, again prior to the critical dates, right? So the question is whether these disclosures were public uses within the meaning of the statutory bar, right? The important thing that the court found here is that the court decides that the only close call here is the typing tester that Mrs. Lanier uses, right? Why were these other disclosures, even though the NDAs had expired, why were these other disclosures not prior public use bars? And the court says the reason that they don't need to worry about those is that when he showed off these ergonomic devices, they were never plugged into computers and they were never actually operated. He was simply showing them. And the court thought that was not enough because he was not using the patent and invention in the way that the statute intended, right? So the statute requires a prior public use, right? Not a prior public showing or description, right? It's a prior public use. And the court says these showings to the investors and to friends were simply not uses, right? They were showings. He told them about it, and in some cases actually showed them models, but that's not enough. If they weren't connected to the computer, which is an essential element of the claims, then they were not using them, right? All right, so that's why the business partner, the friend, the potential investors, those are not prior public uses, right? But what about the tester, right? He hired a typing tester so that he could prove how much faster apparently typing on these keyboards were, and so that seems like a potential use, right? The Cherry Model 5 was used to conduct typing tests in July 1990 and was connected to a computer for its intended purpose, right? The typing test occurred after the critical date then for the 477 patent, right? So now that means that patent cannot be subject to a bar from the typing testing. The 322 patent still might be, right? But the court says Mrs. Lanier appears to have performed a one-time typing test to assess typing speed, right? She signed an NDA on the same day, right? So what the court says, the one-time typing test coupled with a signed NDA and no record of continued use of the Cherry Model 5 by Mrs. Lanier after that date did not elevate to the level of public use, right? So therefore, the court decides that Cherry Model 5 was never actually in public use. The court says all the disclosures of the Cherry Model 5, except for the one-time typing test, only provided a visual view of the new design without any disclosure, right? And then the typing test was done simply once, and there was an NDA signed by the typing tester. It was never used in the normal course of business. It was simply used for a very brief amount of time as a typing test. So the court decides that on all this set of facts, there was not a prior public use for this. All right, so this gives you a sense of the way that the court goes about trying to figure out whether there's a prior public use, right? So the key and the interesting thing about Motionless Keyboard is that the court really focuses there on what is the use, right? What use was made, if any, of the invention. And since a lot of the uses, or a lot of the potentially bar triggering events were not in fact uses but simply showings, they did not count as prior public use, right? Another case that's fun to do, it's mentioned in the notes, I think, is the Moleculon research case, right? The invention here is the Rubik's Cube, and the inventor was a graduate student who built several embodiments of the invention and displayed them to roommates and another graduate student. He also revealed the invention to his employer, right? The Federal Circuit held this was not a prior public use because all of these showings, and indeed they did use it, so they were flipping it around and things like that. So it's not a use issue. The issue here is that the showings that he made of it were done in the context where the inventor kept complete control over the device, Right? So the inventor was not just giving the device out. The public really didn't have any access to it. Although there weren't formal and non-disclosure agreements signed, the court said that, well, he was really just showing his friends when they came over to his house. He showed his potential employer, clearly under the guise of confidentiality. This is not what the court thinks of as public use. Right? So this then begs the question of when is a use prior to the critical date not a public use, right? Because we have the Egbert case, which suggests a pretty expansive understanding of public use, and then the Motionless Keyboard and Moleculon research seem to cut that back, right? All right, so Motionless Keyboard stands for the proposition that in order to be a prior public use, there has to be an actual use of the invention, right? The invention has to be actually used in some way, right? But so that's a key factor, right? A private and non-commercial use is not a public use, okay? Now, you might ask, why the Egbert versus Lippmann case? Well, I think you can understand that case because the inventor's friend was the one who was testing, right? So the inventor repeatedly and over allowed someone other than himself to utilize the invention even without him being present, right? Now, you might argue that this seems pretty similar to the Rubik's Cube case where the court there found that the inventor had only shown this in the context of privacy and friendship. Doesn't that seem a lot like Egbert versus Lippmann? I think that's fair. On the other hand, it does seem like in the Egbert versus Lippmann case, there really wasn't, the inventor was not keeping sort of control over these springs and had simply made these springs for his girlfriend to wear around as she pleased, right? So a private non-commercial use, right, will not be a public bar, right? A private or under the control of the inventor type of use, again, where there's non-disclosure agreement signed or some aspect of control or secrecy, such as Moleculon, are not public uses as well, right? And then finally, a use that's experimental, which we'll turn to in just a moment, is also not a prior public use, right? So are these statutory bars? So here's a machine kept secret, output sold freely. A non-inventor used a machine secretly and freely sold the output. Okay? The courts find that number one here, right, is a statutory bar, even though the public cannot discern the invention. Right? And number two is not a statutory bar. Right? And this distinction here is that who is doing the using of the invention for commercial purposes, right? These are both commercial uses, right? But if it's non-inventor commercial use that's secret, then the court says that is not what is meant by a prior public use, and so that use will not be a bar. Again, assuming that the output is sold in a way that you can't discern the process or the technique for creating the product, right? So page 434, note 3 goes through this in some more detail, so I would recommend that you turn to that and if you want to know more and read about that analysis. But the idea here is that who does the use in this context does matter, right? And we're trying, again, to be careful not to allow inventors to exploit their inventions for too long, okay? All right, so the experimental use exception. A couple of cases here, right? One case is the City of Elizabeth case, right? This is one paving company versus another. This is back in the day when wooden paving blocks were becoming quite common in cities. The cities were moving beyond dirt streets and trying to come up with new techniques and technologies for how to pave streets. And Sam Nicholson was the inventor of a new and improved wooden pavement. Right? It had to do with a sort of border and alternating types of wood system. Right? All right. So the issue here is he places right? These blocks, a large section of his system gets built in the city of Elizabeth, New Jersey. So he was using it for some period of time, long period of time, as part of a toll road. And what happens is when the city of Elizabeth, New Jersey, goes to create their own streets using his patented method, he sues them, and they defend by saying, no, you're invalid, your patent is invalid for a prior public use. He defends by saying, no, my prior use was experimental in nature only, and therefore is not a prior public use. The issue here, and the court agrees with the inventor, right? And what the court says is that it is not a prior public use if the reason that you're using it is for experimentation, right? And the idea here is that there are certain kinds of inventions that need to be used, need to be tested in public in order to be perfected, right? And the evidence in this case shows that the inventor indeed would stop by and would look at the roadway from time to time. There was clearly some sort of testing or evaluation activity going on, and that therefore this was an experimental purpose and not a public use that would violate the public use bar, right? So again, this is another exception for the kinds of uses that can occur before the critical date and not bar, right? An experimental use, right? And the next couple of cases we have sort of explore the contours of what we mean by a experimental use exception, right? So EMD versus GE has to do with bearings for turbochargers, right? And EMD versus GE, EMD is the patentee here, and what they do is they create a new set of bearings, a new type of bearing, new bearing technology apparently, and they engage in sort of a two-phase testing program, where the first phase involves sort of in-house internal testing on the bench, on machines. The second phase of what they call their testing program is that they actually install these bearings into real-world turbochargers for, in this case, locomotive engines, diesel engines that they then sell to customers. Right? And the question is that second phase, which again occurred in some cases before the critical date, is that for experimentation purposes and therefore not a bar, or is that a prior public use, a bar, and therefore the patent is invalid and GE can go ahead and use the technology without paying EMD, right? And so what the court goes through is they say there's a set of factors that have to be evaluated in each case to determine whether or not there are the prior use is an experimental use, right? And then indeed the court says there are 13 factors, right? The necessity for public testing, the amount of control over the experiment, the nature of the invention, the length of the testing period, whether there was payment involved, whether there was a secrecy obligation, whether records of the experiment were kept, who conducted the experiment, the degree of commercial exploitation during the testing, whether the invention reasonably requires evaluation, whether the testing was systematic, whether the inventor continually monitored the testing, and the nature of the contacts made with potential customers, right? And so although the court says the list is not exhaustive, what they're saying is you have to really evaluate in these cases whether there's a true experimentation going on and try and sort out the differences between experimentation and just run-of-the-mill public uses where you're or sales where you're just selling or using the invention in public, right? So what happens here, right, is that the court says that there's really no evidence that on this phase 2 testing that EMD points to that they did anything about evaluating or had any of what the court calls indicia of experimentation, right? They didn't tell Union Pacific, one of the customers, the primary customer, that there was testing going on, and they didn't, put Union Pacific under any sort of non-disclosure agreement or secrecy obligation or anything like that to try and ascertain or to try and keep the invention secret. They don't have to. Again, none of these factors individually are dispositive, but all put together, they point, the court thinks, towards this being a prior public use that's not experimental, right? The court says EMD made very little attempt to monitor the conditions under which Union Pacific used the test locomotives, and they, what EMD says, well, phase 2 of testing isn't really about monitoring as much as it is to evaluate durability, which is, after all, the key to bearings, these type of turbocharger bearings. Durability is the real key, right? And it's not so much that they were trying to perfect the invention by experimentation. They were just wanting the invention used, and the only way to get it used in real-world conditions for long periods of time was to actually install it in customer machines, right? The court found that just unconvincing, right? And I think it's going to be difficult in future cases for people to argue that long-term durability testing allows you to engage in prior public uses. The court seems quite suspicious in the EMD case about the argument that they needed to test it this way, that this was the only way they could achieve durability analysis without by giving it in to customers, right? And so what would you do? I mean, the question I guess I would ask you to think about with respect to the EMD case is, if you are the attorneys for EMD and you want to have this phase 2 of testing, this durability type testing, after reading that opinion, what would you do, right? What kinds of things would you want to do to ensure that you would retain the ability to get your patent, you would stay within the shelter of the experimental use exception? And so I'll leave that to you to think about, and maybe we'll talk about that in class to some degree. Okay? Okay, so let's move on and get to third-party activity. Okay? There are two cases here, right? Lorenz and Evans cooling, right? And the question here is whether a statutory bar can arise even though the inventor is not the one who creates the barring activity, okay? And Lorenz deals with a public use bar, right? So what happens is the patentee, Lorenz, shows the patented process to a chemist at Colgate, right? Colgate declines to pursue the invention, but later files for and receives a patent on the process, right? Lorenz petitions to get its own patent reinstated and eventually files a new patent application and actually wins an interference, right? So what Lorenz does, goes to the patent office, files a new patent application, says, I should have priority over Colgate because I'm the true first inventor, actually is able to win that interference contest, right? So now Lorenz has a patent on this process, and Lorenz sues Colgate, right? Colgate now defends by saying, no, your patent is now invalid because we sold some of the product using this process before the critical date, right? And so we use this process in public well prior to the critical date. Okay. And so Lorenz says, well, that's wrong. That can't be right because it's not. I didn't do it. I'm the inventor, right? And the issue here is Colgate create a on-sale or a public use bar by its own use. Even though what appears to happen is it effectively stole the invention from Lorenz, right? And the court decides that yes, indeed, Lorenz's patent is valid in this case, right? And that because there was a prior public use more than a year prior to Lorenz's application date, then there is a barred use, and therefore the patent is invalid, right? Evans cooling is similar, but it deals with an on-sale issue, right? So Evans creates a new cooling system, demos the cooling system to General Motors. It goes on a Corvette. General Motors doesn't take Evans up on its offer, but goes ahead and offers the system or something very close to it for sale as part of the 1992 Corvette. And some of these initial sales and offers for sale incorporating the cooling system were more than a year prior to the Evans application date, and that thus triggers the on-sale bar. Right? And again, the court, both of these cases stands for the proposition that third-party activity, non-inventor activity, can trigger the on-sale bar. So if there are sales or public uses prior to the critical date, even if they're not by the inventor, right, they can be barring events. And that there is no exception for what might be described as nefarious activity. Right? The fact that in both of these cases, Colgate and GM seem to have effectively stolen the invention and then disclosed it, right? That does not help the inventor, right? It is still a prior public use or on-sale bar, right? So why not, right? Why would there not be an exception for third-party activity generally, right? So the third-party activity doesn't raise the issue of the inventor extending the monopoly or affirmatively trying to dedicate their invention to the public, right? So one of the animating principles that we've discussed in talking about statutory bars really isn't present when we are talking about third-party activities, right? But what controls in these cases is that even though the inventor is not exploiting his or her invention for too long, you still, the court falls back on sort of a principle of novelty, which is the courts believe that activities like sales or public uses that occur more than 1 year prior to the application date effectively give the invention to the public. Right? And that very much the same as the novelty principle. We don't want to allow people to get patents on things and therefore withdraw them from public access. The court says once it's been on sale or offered or used to the public more than a year prior, it can no longer be patented. Right? So it really sounds quite similar to a novelty principle as well. So one of the interesting things about statutory bars is it mixes in these principles of both trying to prevent the inventor from over-exploiting his or her invention as well as preserving novelty and the concept of novelty. Those are both at work in these cases. When it's a first-party bar, we're usually talking about things like the inventor over-exploiting the invention, but the third-party bars really can only be explained in sort of novelty terms, right? But that still doesn't explain why why we don't have an exception for nefarious activity. I mean, is it fair to Lorenz or Evans to say that if you have your invention stolen from you, that then you can lose your right to a patent, right? Is it fair to the inventors? Is it fair to the public, right? So the courts seem to think here that although it's clearly unfair to the inventors, and in both of those cases they certainly hint that the inventors may well have some sort of remedy against Colgate or General Motors, maybe through fraud. If there was an NDA, you might have some sort of a contract claim, something like that. That really it's the public at the end of the day that we care about, right? And the fact that is that once something is on sale or used in public more than a year prior to the critical date, it's essentially given to the public, right? And even though the way it got there may be nefarious, the law, the policy doesn't care, and we still can't allow people to withdraw things from the public domain once they've been offered that way, right? So what about the incentives here, right? So for one thing, you got to be careful about who you disclose to, right? And second, any kind of disclosure of your invention that you make, to be safe, you really need to follow up with a patent application very shortly thereafter, certainly within a year. So it just makes it much more important to think about these issues. Now, unfortunately, this type of rule almost certainly has distributional consequences, right? I mean, the people who are going to get tripped up by third-party activities are the people who are not well advised by lawyers, maybe who don't have a lot of resources, who are in other ways potentially taken advantage of. So that's somewhat problematic, right? So the upshot here is that the way to think about these third-party bars is you need to be very careful as an inventor to make sure that anytime you're giving disclosures of your invention, even if you have non-disclosure agreements, even if you have promises of secrecy, that is not going to protect you if the person you've disclosed it to violates those agreements. You may have a contract claim or some sort of fraud claim against them, but your patent may be gone unless you follow up quickly after your disclosure with a patent application. Right? So these are all, this chart I think tries to lay out all the different types of activities that can occur. Patented process used secretly by the inventor is not a bar. A patented process used secretly by the inventor for commercial purposes, for example, the output is sold, is a bar. By metallizing engineering stands for that proposition. A patented process used secretly by a non-inventor is not a bar, right? And a patented process used secretly by a non-inventor for a commercial purpose is also not a bar. So again, what we mean by this sort of secret third-party use is that we mean that secret third-party use, even for commercial purposes, won't be a bar, but secret use for commercial purposes by the inventor will be a bar. Right? So the metallizing engineering versus W.L. Gore is an important set of cases to keep in mind. That distinction between the two outcomes is really explained by the fact that part of what we're trying to get with Section 102B is to prevent patentees from being able to overexploit, to lengthen their patent term more than they should be able to. So that's Lecture 9, Novelty 3, Statutory Bars, and I'll see you next time.